Hello, ladies and gentlemen. Today I am going to be sharing my thoughts on a very existential topic, according to me, which is effective client lawyer relationship, with a lot of emphasis on effective and client. Because let's understand, it is the litigant or the client who starts the wheels of our justice dispensation system. And maybe it's a good idea to go back and revisit the roots of our profession. Before I start on the talk, I wish to thank the organizers of the Sunday Club for giving me this opportunity to share my views on this topic. I really wish this had been an interactive session because I would have got to know so much from all of you from your personal experiences. But I guess we are all in a situation and we go with the flow. Right, so coming to the topic of discussion today, when we are talking about a client-lawyer relationship, we need to step back a little into history. And as all of us are aware, in the earlier times, when it came to dispute resolution, it used to be an elder, maybe in the family or in the village, who would resolve disputes. So whoever was aggrieved, in our jargon, the plaintiff or the petitioner or the complainant, would go to this elder, and the elder would then call the other side, issuance of notice in our parlance, and then the elder would listen to both the sides, audi alteram partem in our jargon, and give the decision. Invariably, it used to be some social more or some custom that used to be the guiding factor. Equity used to play a big role. So a whole lot of such factors, and it was as simple as that. Now, eventually, rules came into existence, there was a crystallization of regulations, and it became a tad difficult for the aggrieved to effectively put forth his cause. And that is when a friend stepped into the picture. Someone who knew him personally, someone who knew the situation, someone who could vouch for him. And that is where, as a friend of the party, the seeds of our profession were sown. Now, if the aggrieved gets represented by someone, it is only natural that the opposite side also should get a friend. So, Article 14 at its best. So, eventually, we had a situation where both parties were represented by friends. Over a period of time, it was felt that a few more skills were required by these friends. They had to have some acumen and a bit of a training. And finally, we have landed up with the legal profession as we know today. So, a friend of the client is the key word that we have to keep in mind. So, coming to the current times, India is still a country where court is the last option. We are not like the American situation where at the drop of a hat, people go to court and say, this is violated and that is violated. No. Here, there is a lot of hesitation still to come to court. And after almost every possible situation has been explored, court is seen as the last hope for the litigant. So once the litigant decides to come to court, the next question is, who is to represent the litigant? So the litigant will do a bit of research, he will ask around. Traditionally, litigants ask their near and dear, and someone will know some lawyer, someone would have gone to some lawyer, etc., etc. And it is by word of mouth, because as per Bar Council rules, in India we don't solicit clients. It is the litigant who finds his or her lawyer. So that is one category of litigant who by word of mouth and reference zeroes in upon a lawyer. In the current scenario, there's another category whom I would call the Google category. So this is a category which will type our name into Google and read up everything that is available on the internet to understand who we are or our credentials. Now, if we think that we are far away from the madding crowd of the internet, we may be mistaken. Unknowingly, somewhere there will be some footstep. If not any other footstep, you can depend on Just Dial. Just Dial, like it or leave it, has you as a part of their database, and they would have created a profile of yours, whatever they think is the profile, and put it up on the internet. So all said and done, what I want to say here is, today's litigant is an aware litigant. He's not someone who has straddled in by chance into our office. He has done his research, he has understood who he is coming to. So, according to me, in that context, our duty as lawyers go much beyond the point where the client enters our office. We need to have a positive image, a reputation, the right kind of vibes. Now, how we create that is left to each one of us. But suffice to say, each time we are seen in society, we are identified first by our profession and then as individuals. So let's understand, inadvertently, we are brand ambassadors of our profession wherever we go, and we get identified by that. Of course, we have a Facebook page concept, we have a website concept. I don't know, because as per our Bar Council rules, we are not supposed to advertise. But a Facebook or a web profile can be counterproductive. They're very similar to a Hindi movie or a Kannada movie situation. The client sees these movies and comes with all kinds of dramatic expectations. And I've actually had clients who say, "Madam, this is court. The judge is not well. He didn't say order, order. And you're supposed to fight, no? All of you are being so decent. Is this how the court works?" So then you have to show them, you have to tell them, convince them this is the reality and that is drama. So a similar situation can happen if we over-profile or over-glorify ourselves on the net. It may be tough for us to handle when the client comes to us in reality. So that's one aspect. But my understanding is the ultimate credentials for an advocate is a clear conscience and a clean hand. Nothing can beat these two aspects. Fine. So there is this client who steps into the office. And when the client steps into the office, he is gauging us. He's looking at the office, he's looking at the furniture, he's looking at what you're wearing, what is the kind of presence that you have in the office, all this. And it really depends on the client what he's looking for. Because I have had clients who come to me saying, "Madam, I went to so-and-so's office. My God, it's so posh and such, so much of opulence and stuff." I said, "No, this is not my kind of lawyer. I can't afford such lawyers." See, in all probability, if he had gone and spoken to the lawyer, he would have found that the lawyer was actually going to be charging him reasonably. But then he was so taken aback and so awestruck by the general aura of the office that he decided not to go into the office at all. But of course, there are also clients who judge a lawyer by the office. So, variety is the spice of life. So each client to his own whims and fancies. Helps us to be aware of some of the factors that run in a litigant's mind. So he comes into our office, and let's understand, when a litigant comes to us, he has or she has a kaleidoscope of emotions running through him or her. There are so many anxieties, there are so many confusions, and that one thing that we should probably give the client at that point is empathy. A lot of empathy. Now, what do I mean by empathy? It's a human touch. Treat them like human beings, understand the human factors involved, understand their emotions, understand their situation. That reminds me of our professional costume. We wear a black gown and a black coat because the color black signifies empathy. We are supposed to empathize with the client. And the band that we wear with the two tongues in it, the white band, one tongue is supposed to signify our duties towards the court, and the other tongue is supposed to signify our duties to our client. So as long as we keep these two duties in mind constantly, which is why we tie the band so tightly around our neck so that we're constantly reminded of these two duties, there is no way we can falter as officers of the court and friends of the client. So there is this client now with all this emotion, and you're trying to empathize, you're trying to give the right vibes and confidence. Because again, let's remember, our profession is not a business. So we are not transacting with the client. We are a service-oriented profession. We are creating relationships. We're looking at bonding with the client. So again, a human factor comes into it. So when the client comes in, he or she, as I said, is agitated. Now, generally what happens is we have some colleagues in our office. They are a part and parcel of our office. So They are there in all our briefings and stuff. But for a client, he or she may not be comfortable with a third party in the cabin of the advocate. He or she is trying to create a rapport with the advocate. So, issues of confidentiality, sense of privacy, all this may run through, and the client would probably be more at ease if he or she interacted on a one-to-one basis with the advocate. And then the client begins his or her story. He's not going to tell you, or she's not going to tell you the entire story at one stage. They will just give you a summary, because there's another predominant concern that is bothering them at the back of their mind. That is the fee structure, the affordability of the lawyer. So they'll probably give you a summary of what the problem is and say, how much would it be, madam? Now, I have some friends who say, if we told the actual cost, they will never come back to us. So, we'll say so much and then let's see. Now, I have had clients coming back and saying, madam, in all good faith, I asked the lawyer what would be the amount. This was the amount told to me. I made my arrangements and I was prepared for that. Now, once the process started, one after the other, on some pretext or the other, they started asking money. Now, I have come to a stage where I cannot afford this lawyer anymore. So I got an NOC. Please appear for me. I don't think we should do this to the client. See, if a client has taken so much pains to research and understand our background and step into our office, in all probability, he also has an understanding of what fee structure to expect. See, there are so many ways of fixing the fee. It can be in installments, it can be stage-wise. There are so many ways in which a client can make payments to the advocate. So understand what would be the best way for him to pay the fee and give him a reasonable amount, which is your fee, so that he is prepared. So once the fee aspect is out of the picture, believe me, 50% of the client's anxiety is gone. Now he's free, he is confident that he can go ahead with you, and now he will pour out with his story. So as I said, there'll be a lot of venting happening, there'll be a lot of frustrations that will come out. Allow him or her to make it a free flow. Do not intervene. Now, there are some professional hazards over here. We tend to interject. Now, when we tend to interject, we tend to advise. And I have had clients saying, madam, I had just started, and then the advocate started lecturing me. The advocate said, what is this? Such a trivial thing. You know what all we have gone through. And then he or she will start talking about his family or her family and how much they suffered. Then they talk about how their work experience is, how much they toiled. Madam, 2 hours I sat there and nothing really happened. They didn't really seem to be interested in understanding what my plight is. Let us not get into this. And they started advising me, you should go back, you should do this, you should do that. Ma'am, I know what I want out of my life. I don't want anyone dictating terms. Let's understand that. Dictating. We are here to take instructions from the client, not to dictate terms, not to decide the destiny of the client. We are basically a catalyst at this stage to try and help the client understand what is the best possible solution for him or her. So what we should probably be doing is give various options once this entire venting out has happened. Give various options and help the client understand which would be the best option for him or her. Because remember, it is he or she who has to live through that option. It's not us. According to me, A may be the best possible solution. But according to the client, C may be better because he or she feels that's a more doable thing from her perspective. Allow the client to have a say in his or her matter, because today we are in a hands-on world, in a participative world. The client wants to be in charge of his or her life, and fair enough, and it's a good trend. So let us understand that sentiment of the client. So there are various things that can happen after this venting out session. So I have had situations where the client says, madam, I feel so good talking to you, such a big burden off my chest. And now I realize, as I'm talking to you, I realized that maybe it is not all that bad. Maybe I should go back and give it another shot. So in that initial stage, we are basically more like a counselor to the client. So after the venting out, if this is what a client feels, no problem. Let us not get into the mode of, no, your rights are violated, you should teach him a lesson, come to court. No, again, remember, as officers of the court, we must ensure that court is the last remedy still. Let us not add to the docket explosion in court. Remember, we have alternate dispute resolution systems just to ensure that the mainstream court process is not burdened. So we also have that duty at our office level also. So if this client says, I think I'll go back and give it another shot, collect your consultation fee, let her or him go back. And I'm sure it's been the experience of all of you also, that there will come a time where probably 1 year down the line or even 5 years down the line, this client will come back if it does not work out. And this time when the client comes to you, no research has happened, no cross-checking has happened, because the client has struck the right rapport with you. You have managed to give the kind of trust and confidence and empathy to this client to decide without batting an eyelid that you are going to represent his or her case. So this is one category of client. Then there is another category, a very interesting category, which is on the rise these days. Madam, actually, you're the third person I have come to. See, by and large, what you have said is very much like what the other advocate said. I just wanted to check. My cousin is a lawyer and my friend also is a lawyer, but I will get in touch with you. Rest assured, the man is not, or the woman is not going to come back to you. That is fine. No hard feelings. Collect your consultation charge. There ends the story as far as that client is concerned. Then you have the other category where the client has decided, yes, whatever it is, ma'am, let's go ahead. There again, there are categories or subcategories, if I may say so. There will be one category of clients who will say, madam, I really don't have time and I really can't be bothered which way it goes. Just finish it off one way or the other. So time is a very, very important factor for this category of clients. There is another category which says, now when I'm saying category, let us not categorize clients as a class. Let's understand each client is an individual in his or her own right. I'm using the word category only to make it easier for us to understand. So there's this other category which says, I don't care if this goes on for another generation. I want to teach him a lesson. What does he think of me? So it's a sense of justice that this client is looking for. And then there's also another category of client who says, madam, I've come to you because I think court is an option. But you know what? This is my first experience with court. No one in the family has gone and I'm not really comfortable. Can you still think of something where I can avoid court? I can probably settle it in some manner without court. Now here, if you are confident, that is, and if you have 100% approval and trust of the client, maybe you can try for a mediation. Call the other side and see how it works out. It works out, there ends the matter. Doesn't work out, litigation. So all said and done, we are now at the stage of litigation. And let us now remember, time is a crucial factor. Time is a crucial factor not just for us, but for clients also. So the client will ask you, how long will this go on? So it is very important that we involve the client as a partner in the litigation process so that he or she understands. Now, when I'm talking about time factor, I have had clients who say, madam, I went to this advocate. There were some 10-15 people waiting in that office to meet him. It was some 5 hours before I actually got to meet him. I cannot afford that kind of time. And every time my lawyer expects me, for the smallest of reason, he expects me to go and meet him. I cannot do that. Now, here as lawyers, we think, the more number of clients we have, they're going to think I'm a big lawyer, I'm so busy, and, it adds to my aura. I don't think that works anymore. There's also another thing that happens, as we are talking to a client during that interaction period where they're venting out, we inadvertently start comparing the client's situation with probably a case that we have handled previously. And then we say, some of us want to show off that so-and-so is my client. And this is the kind of people that I, appear for. Oh, the same thing happened in that matter also of so-and-so. So you know what? Now, you know what the client is going to think over there? The client is going to think, today this lawyer is talking about so and so by identity to me. Tomorrow, he or she is going to do the same thing about me to someone else. I don't think confidentiality is going to be maintained over here. Let me think about this lawyer. So let's be very careful on that professional hazard also. So anyways, let's get down to the litigation process. It is always a good idea to ask the client to give a summary of all that he or she has stated to us in that first client meeting. The advantage is that, of course, there's a lot of clarity for us to draft the petition or the plaint with dates and facts. Also, a situation where if the client by oversight has missed telling us something, that can be added. And let us remember, this petition or plaint that we draft is going to be the foundation of the case right up till the Supreme Court. So it is so important that the right kind of drafting happens. Now, how we do that is a topic of another talk, so let's not get into that. Now we file this case, and as I said, it is always a good idea to make the litigant a partner in the litigation process. Let the litigant come a couple of times, or if he or she is interested in coming more often, allow them to come. Let them know what is happening. I'll tell you why it is important and advantages for us. To begin with, the client will understand the court situation, understand the mindset of the judge or the presiding officer, get used to the court situation. And in the case of a trial court, by the time the client comes to the cross-examination stage and gets into the witness box, the client is very confident because he has reached or she has reached a certain comfort level in that court hall. And that makes it so easy for him or her to face a cross-examination. And then at the time of argument, be it at the High Court or the trial court or the tribunal, it is always a good idea to have the client present in court while the argument goes on, because there may be something which comes up suddenly. Even at the time of cross-examination of the other side, it's always better to have the client because there may be something which you need immediate clarification on, and it's always nice to have the client there with us. Then comes the judgment. My experience has been, when it is a participative exercise, the judgment is a mere formality for the client. I have had situations where I have not succeeded in a case. The client has come up to me and said, "Madam, don't worry. We did our best. We did our best." That makes all the difference. That sense of collaboration, it makes all the difference. And I feel so satisfied when they say that. And they will say, "There's the next step, madam. We will try. Don't worry." And I have had clients who at the end of the entire litigation process come to me and say, "Madam, we are so glad we went through this situation, and we have to thank the other side for putting us through this situation, because I have learned so much in the process. I am so much more confident now as an individual, and I know I will never get taken for a ride again. Thank you so much." And that is the best fee I can ever expect from the client. And the added satisfaction is, this is a client who is going out with so much of confidence and satisfaction with the justice dispensation system. And this is a client who is confident that he or she will not get taken for a ride. So as an officer of the court, you have preempted unnecessary litigation. He or she will come only when there is an absolute necessity and need for litigation. I think that is the ultimate fulfillment of our duties. So this is by and large in the litigation process. Now, inadvertently, there are certain, I don't want to say faults, I would want to say inadvertently we land up making certain or uttering negative things, or indulging in certain actions which don't quite gel with what a client would want of us. Let me just list out, there's a long list, but let me just give a gist of what I'm trying to say. So I have had clients who come and say, "Madam, I am planning to get an NOC from this lawyer, so I want to know what your opinion is." I said, "See, if you have already got a lawyer, it's not fair for me to involve myself. But before you tell me about the case, tell me why you don't want to be with that lawyer." "Madam, Even before I say something, he flares up. He has no patience to listen to me. I've tried once, twice, thrice. He just not does not listen to me. And I tell him to say something in court, he does not say anything. If I try to say something, he's, Madam, I just cannot gel with this man. We have to be very careful. Now, we also are human beings. We take in a lot of negativity and frustration during the course of our profession. But we must make a conscious effort not to mix up our personal situations with the professional situation. We may have had an argument with someone, we may have had a disappointing experience. If we are not able to put on a neutral interaction with the client, I suggest it's a good idea to even cancel an appointment. At no point of time should a negative vibe go to the client. And the most important thing for our profession is listen. Let us listen to the client. I talked about empathy. Listening is a very important part of that. Communication is a very important aspect of a lawyer-client relationship. And an important aspect of communication is listening. Let us listen to what the client has to say. So where an NOC has not been got already, I have had the opportunity to kind of counsel the client and say, why don't you just go talk to your lawyer? Tell him that you want him to listen to you, otherwise you're going to think of an alternative. The minute that happens, there have been instances where the lawyer has understood his or her mistake and everything has been fine. Of course, the lawyer never gets to know that the client has already visited another lawyer, because I tell the client never to say that to the lawyer. And I feel so happy in reuniting a client with his or her lawyer. So that's one aspect of it. Now, another thing that we'll end up doing, I've seen some advocates doing, is, I don't know if I should call this as favor, but for example, if the client is running a resort somewhere, oh, you have a resort, I'll come with my family this weekend. And it's implied that it's all going to be free of cost. Let's look at this logically. When he comes to me for my services, I expect a fee. Now, when I go to him, I expect everything to be free of cost. Now, do you really think that's the right thing to do? Do you really think a client is going to respect us? We should be so careful that we are not a nuisance factor to the client, and we should not become parasites of our client. We need to be professional and maintain a certain element of dignity with our clients. Another faux pas on our part, we'll end up, some of us, making character sketches of judges and fellow professionals. Do we want our clients to think, my God, this lawyer is so petty? Let us desist from that temptation. And another thing is costume. I already said, a sense of dressing. See, all of us have a right to be fashionable and be as innovative in our dressing as possible. The Bar Council has stipulated what the uniform for advocates are. But over and above that, we have fashionistas and dudes who want to have their own variations. May not go well with the client. I've had clients saying, Madam, that girl is so obsessed with her hair and her mobile and those danglers. She doesn't seem to be serious. Whereas she may be. But look, this is the impression one's attire is giving to the client. Now, I'll be gender neutral over here. That boy, ma'am, I don't know. I think he's come to this profession by mistake. He comes in jeans and sneakers. Does anyone come like that to court? There has to be some kind of seriousness, no? So, when we're talking about dressing, our client expects us to exude a sense of confidence and a sober attitude. We need to give that impression that we are there for serious business. So let's keep that also in mind. And another thing is technology. In today's world, we cannot remain in our cocoons and say, oh, in our good old times, this is how it used to be, so it should be like that. Time is a very, very important factor. So that first client meeting, give as much time as you can to your client, create a bond. Thereafter, right up till the end, unless you're talking about court visits by the client, most of the interactions can happen through telephonic conversations or mobile conversations in today's world, or emails or WhatsApp messages. Let's use technology. And the client is really going to bless us, because time is a factor for everyone. And no, you don't have to compromise on your consultation fee. You can structure the fee payment in such a way that all these interactions over mails or phones also can be factored in. So at the end of the day, let's look at our clients as partners in the litigation process. Now, if we were to think about the immediate situation, a post-lockdown situation, there are going to be a lot of interesting propositions that are going to come up. There are going to be new situations. We may have to save livelihoods. We may have to reinterpret Article 21, for example. Some of the traditional fields of law may just get wiped out. New fields of law may come up. So we have to be constantly in touch with the changing times. Because remember, as lawyers, we are also meant to be social engineers, trying to understand and trying to influence the mind of the society. So we need to feel the pulse of the society. And one professional hazard, again, according to me, is we so clutter ourselves, and if I may use the word, indigest ourselves with case laws, and we think that we know so much about a branch of law. It is actually to our disadvantage. Today, unfortunately, I think most of us are so well versed in case laws that we have forgotten what the law itself is. And because we know so much about a particular field through so many case laws, unconsciously or subconsciously, we have certain mental blocks about certain fields of law, or we think this field of law can be interpreted only in this manner. This provision cannot be interpreted in any other manner. So I think we must declutter ourselves. I think we should start on a fresh slate, because post this lockdown, we are going to have some very, very basic issues to understand. And it makes a lot of sense to get back to the basic statute, the basic wording of the provision, understand how to relate it to the ground reality. And only if we require some clarification or some further interpretation, then we take the assistance, I use the word assistance, of case laws. Let us not become dependent on case laws. Let us become original thinkers. We need the law to change with the times, to adapt to the times. And that is where we need effective lawyering today, not academic lawyering. We need thinking advocates, not advocates who just parrot one case law after the other. Here I'm reminded of some interesting lines of William Wordsworth. He says, "Enough of science and of art, give up those barren leaves. Come forth and bring with you a heart that watches and receives." To be an effective lawyer, we have to be updated with current affairs. We need to know exactly what's happening where. And yes, like it or leave it, we have to be a jack of all trades. We need to be knowing as much as possible about everything and anything under the sun. In fact, I have twisted this jack of all trades phrase. The phrase actually says jack of all trades but master of none, but I always say that lawyers are jacks of all trades and master of one, which is jacking all trades. So that is the kind of preparation that is required of us as lawyers. So to put it in a nutshell, when it comes to a client-lawyer interaction in today's world, let's try to treat our clients as partners in the litigation process. Let's be human. The only reason artificial intelligence has not taken over yet is because of that human factor that exists in our profession. The minute we start giving up one after the other our roles to technology, we are just inviting artificial intelligence to take over. We are just nailing our own coffins. We have no room for being lethargic. So let's understand the significance and symbolisms of the attire we wear, and let's try to be true to the two duties that are signified by the band that we use. And let us never forget one important phrase: a friend in need is a friend indeed. And that is what a lawyer is supposed to be for his client. I'll wind up on that note. Thank you so much for listening.